Hello everyone, and welcome to Understanding and Applying the Americans with Disabilities Act Amendments Act and its regulations. Thank you for choosing this module from the Job Accommodation Network, or JAN for short. JAN is a free service funded by the U.S. Department of Labor's Office of Disability Employment Policy. As our name indicates, we specialize in providing information about all aspects of job accommodations. We also provide information on the employment provisions of the Americans with Disabilities Act, or ADA for short, and self-employment for people with disabilities. All of the information and services we provide are available free of charge. As you might imagine, we get a lot of questions about who's covered by the ADA. Before an employer has any obligation under the ADA to provide an accommodation for an employee, that employee has to meet the ADA's definition of disability. And after the ADA's definition was amended, we started receiving even more questions about the definition of disability. In this module, we're going to discuss the ADA Amendments Act and the regulations that help us understand who is now covered by the ADA. Our discussion will include some background information about why the Amendments Act was needed, the Act's overall purpose, the new broadened definition of disability, and the Act's workplace implication. So let's start with some background information. On January 1st, 2009, the ADA Amendments Act went into effect, making some major changes to the way the definition of disability was interpreted in the past. Very few people argued that these changes weren't needed. The courts had interpreted the definition of disability so narrowly that hardly anyone could meet it. In many cases, people with conditions like cancer, diabetes, multiple sclerosis, epilepsy, and HIV weren't even covered under the old definition. So the definition was amended so more people would be protected from disability-based discrimination. The big issue was just how broad to make the definition. But after much debate between the business and disability communities, the Amendments Act was finally passed in September of 2008. In the Amendments Act, Congress gave the Equal Employment Opportunity Commission, EEOC for short, the authority to revise its regulations regarding the definition of disability to make them consistent with the Act's purpose. On March 25, 2011, the EEOC issued long-awaited final regulations. These regulations went into effect on May 24, 2011. The new regulations closely track what Congress laid out in the Amendments Act itself, but provide clarification and lots of examples, which we'll talk about today. Also, it's important to know that a lot of the old ADA regulations remain in effect. The EEOC only changed the regulations that dealt with the definition of disability. So what did Congress hope to achieve with the Amendments Act? The hope was that by broadening the definition of disability, it would be easier for people to show they have a disability. Employers would stop focusing so much on the definition of disability and would focus instead on making sure they don't discriminate on the basis of real or perceived disabilities. Ultimately, this would mean that more people with disabilities can work, and as we all know, work is an important part of most people's lives in our society. So let's look at how the Amendments Act broadened the definition of disability. The first thing you need to know is that the actual wording of the definition of disability did not change. It's exactly the same as it was. It's still a three-part definition. A person has a disability if he, 1, has a physical or mental impairment that substantially limits one or more major life activities, or 2, has a record of such an impairment, or 3, is regarded as having an impairment. So as I have said, this is the same wording we had before. It didn't change. What did change is the meaning of some of the words used in the definition and the way those words are to be applied to individuals. So let's take a look at how the words did and didn't change. The Amendments Act did not change the definition of the word impairment. I'm going to read the definition to you just to show you how broad it is, but don't bother trying to memorize it. It has way too many big words. All right, here we go. The term impairment is defined as 1. Any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more body systems, such as neurological, musculoskeletal, special sense organs, respiratory, cardiovascular, reproductive, digestive, genitourinary, immune, circulatory, hemic, lymphatic, skin and endocrine, or 2, any mental or psychological disorder such as an intellectual disability, formerly termed mental retardation, organic brain syndrome, emotional or mental illness, and specific learning disabilities. As I mentioned, the definition of impairment is very broad, but there are some exclusions. It does not include physical characteristics such as eye color, hair color, left-handedness, or height, weight, or muscle tone that are within normal range and not the result of a disorder, characteristic predisposition to illness or disease, pregnancy, common personality traits such as poor judgment or a quick temper where these are not symptoms of a disorder, or environmental, cultural, or economic disadvantages such as poverty, lack of education, or a prison record. Now let's look at the changes to the term major life activities. The Amendments Act and the regulations made a very important change here, but also retained previously recognized activities, which include activities such as caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, sitting, reaching, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, interacting with others, and working. These were, for the most part, always accepted as examples of major life activities under the ADA. Where the confusion came in was whether someone with a medical condition that only affected internal functions would be covered. Conditions such as cancer, sleep disorders, diabetes, epilepsy, and heart disease often only affect internal bodily functions without producing any outward limitations, and courts grappled with whether bodily functions were classified as major life activities. Now the confusion has been cleared up. The Amendments Act specifically says that bodily functions are major life activities. This is a huge change that added a whole new category of activities, including functions of the immune system, special sense organs and skin, normal cell growth, and digestive, genitourinary, bowel, bladder, neurological, brain, respiratory, circulatory, cardiovascular, endocrine, hemic, lymphatic, musculoskeletal, and reproductive functions. The regulations state that the operation of a major bodily function also includes the operation of an individual organ within a body system. Note that the lists provided in the definition of major life activities are not exhaustive. They are just examples of some of the activities that can be considered, so we may see even more activities added in the future. Let's look at an example. A person with breast cancer was experiencing fatigue for a few days after each chemo treatment. Otherwise, she had no other limitations. She asked her employer to allow her to take off a couple days a month when the fatigue was the worst, and to be allowed to take rest breaks at work on other days. In the past, before the ADA was amended, she most likely would not have been protected by the ADA, and her employer could have denied her request and even disciplined her for missing work. Fatigue just didn't generally fit the old definition of major life activities, so she couldn't meet the definition of disability. Now we have this new category, major bodily functions, that includes normal cell growth, and we know cancer causes abnormal cell growth, so this person with cancer would now likely be covered. This means that today she would probably be able to get the accommodation she needs to be able to keep her job. Okay, now let's move on to another very important term in the definition of disability, and that's the term substantially limits. There really isn't a definition of substantially limits in the Amendments Act itself. Instead, Congress told the EEOC to revise its regulations regarding the definition of substantially limits. In the past, the EEOC regulations had defined substantially limits as significantly restricted, but Congress said that's too high a standard. Make it an easier standard to meet. In the final regulations, the EEOC did not specifically define substantially limits, but instead provided guidance referred to as rules of construction. There are 9 rules of construction, and we're going to take a quick look at each one. The first rule of construction states that the term substantially limits shall be construed broadly in favor of expansive coverage to the maximum extent permitted by the terms of the ADA, and that it's not meant to be a demanding standard. In other words, a lot more individuals should be considered substantially limited now if we adjust our thinking about the definition of disability as Congress intended. The second rule of construction says that when you're looking at whether someone is substantially limited, you're comparing that person to most people in the general population, and an impairment need not prevent or significantly or severely restrict the individual from performing a major life activity in order to be considered substantially limiting. The comparison to most people in the general population continues to mean a comparison to other people in the general population, not a comparison to those similarly situated. For example, the ability of an individual with an amputated limb to perform the major life activity of walking is compared to other people in the general population, not to other amputees. The third rule of construction is that assessing whether a person is substantially limited should usually be done quickly. Remember, we no longer want to be focusing a lot on whether a person has a disability. So in the regulations, the EEOC specifically says that determining whether an impairment substantially limits a major life activity should be done quickly and should not demand extensive analysis. The fourth rule of construction says that the determination of whether an impairment substantially limits a major life activity still requires an individualized assessment. There is no list of conditions that are always automatically covered. However, in making this assessment, substantially limits should be considered a much lower standard than it was prior to the Amendments Act. But even with this lower standard, the EEOC points out that not every impairment will meet the definition of disability. Moving on to Rule 5. When you're comparing an individual's performance of a major life activity to the performance of the same major life activity by most people in the general population, you usually won't need to have scientific, medical, or statistical analysis. Nothing prohibits the presentation of scientific, medical, or statistical evidence to make such a comparison where appropriate, but you usually aren't going to need this type of proof. Instead, we can just use common sense. For example, we know that if a person is paraplegic and uses a wheelchair, that person is substantially limited in walking when compared to the general population. We don't need to do a scientific comparison to figure that out. Moving on to Rule 6. Mitigating measures will not be considered. This is a very important change the Amendments Act made, so I want to spend a few minutes talking about it before we go on to the rest of the rules of construction. When determining whether a person is substantially limited in a major life activity, we ignore the beneficial effects of mitigating measures. In the past, the U.S. Supreme Court held the opposite, that you do not ignore mitigating measures. This holding resulted in a lot of people not being covered by the ADA. People with conditions such as epilepsy, diabetes, and mental illness who controlled their symptoms through measures like medication, good diet, and regular sleep. Prior to the Supreme Court holding, few people questioned whether individuals with these types of conditions had disabilities. But after the holding, it was clear that many of them did not, at least not under the ADA definition. The Amendments Act rejected the Supreme Court's holding regarding the use of mitigating measures. And note that it's just the beneficial effects of mitigating measures that are ignored. If the mitigating measure itself causes any limitations, then those will be considered when looking at how limited a person is. So let's break this down a little further. First, let's talk about what a mitigating measure is. Mitigating measures are things that people use to lessen the effects of their medical conditions. According to the Amendments Act and its regulations, mitigating measures include things such as medication, medical supplies, equipment or appliances, low vision devices, prosthetics, hearing aids and cochlear implants, mobility devices, and oxygen therapy equipment and supplies. Mitigating measures also include the use of assistive technology, reasonable accommodations, or auxiliary aids or services, learned behavioral or adaptive neurological modifications, and psychotherapy, behavioral therapy, or physical therapy. Now, there's an important exception to the rule about mitigating measures. When determining whether a person has a disability, we don't ignore the benefits people get from wearing ordinary eyeglasses or contact lenses. Those we do take into account when determining whether a person is substantially limited. So if the only impairment you have is a vision impairment that is fully corrected by eyeglasses or contact lenses, you're not covered by the ADA even if you can't see a foot in front of you without your glasses. And what are ordinary eyeglasses or contact lenses? They're lenses that are intended to fully correct visual acuity or to eliminate refractive error. Distinguish that definition from low vision devices defined as devices that magnify, enhance, or otherwise augment a visual image. These we would ignore because they are not ordinary glasses that most of us wear. So because of the changes in how we look at mitigating measures, a person can meet the definition of disability even if the person never actually had limitations or had only minor limitations before starting to use the mitigating measure. In other words, people don't have to wait until they're substantially limited and then start taking medication in order to be covered under the ADA. We're going to consider how a person would be limited if he never took medication, regardless of when he started taking it. Also, if a person chooses not to use a mitigating measure and therefore has limitations he wouldn't otherwise have, he can still meet the definition of disability based on his limitations. However, he must be qualified to perform his job without posing a direct threat to himself or others despite his limitations. So if we're supposed to ignore the beneficial effects of mitigating measures, how do we do that? How can we tell what a person's limitations would be if they didn't use the mitigating measure? According to the regulations, evidence showing that an impairment would be substantially limiting without mitigating measures could include evidence of limitations that a person experienced prior to using a mitigating measure, evidence concerning the expected course of a particular disorder absent mitigating measures, or readily available or reliable information of other types. And just a reminder here, none of these options should demand extensive analysis. It should be a quick process. Let's take a look at an example. A newly hired employee discloses to his employer that he has insulin-dependent diabetes and will need periodic rest breaks to take his insulin and eat a snack or a small meal. He says he's not having any problems with his condition, but he needs a regular schedule to maintain his health. His employer can't look at him and verify he has diabetes and is substantially limited, so requests medical documentation. But what documentation is needed? The employer has the right to know that the employee really has diabetes and how limited he would be without the insulin. The employer could simply ask the employee's doctor to confirm he has diabetes and to indicate how limited he would be if he did not get his insulin. Or the employer could just get the diagnosis if the employer, like most of us, already knows what would happen to an insulin-dependent diabetic who didn't take insulin. Either way, when determining whether the employee has a disability, we don't care what the limitations are after medication and regular diet. We want to know what the limitations would be without those mitigating measures. Okay, that's Rule 6. Let's move on to Rule 7. In the past, a person whose condition was in remission or whose limitations came and went might not have been covered by the ADA, depending on how long that person's limitations were in an active state. This meant that a person with, for example, mental illness might not be entitled to accommodations in the workplace, even when her condition was active, if it wasn't in its active state long enough for her to meet the ADA's definition of disability. Now, the fact that the periods during which an episodic impairment is active and substantially limits a major life activity may be brief or occur infrequently is no longer relevant to determining whether the impairment substantially limits a major life activity. Because when determining whether a person is substantially limited, the only thing we care about is the limitations the person has when her condition is in an active state. Okay, we're almost at the end of the rules related to determining whether someone is substantially limited in a major life activity. Rule 8 is that an impairment need only substantially limit one major life activity to be considered a disability under the ADA. For example, an individual with diabetes is substantially limited in endocrine function. He doesn't also have to show that he's substantially limited in eating to qualify for coverage. Congress added this rule because in the past, some courts said a person had to be limited in more than one major life activity to meet the definition of disability. Before we move on to the final rule of construction, let's look at an example that illustrates both Rules 7 and 8. Due to downsizing, an employer has to reassign employees to different shifts. An employee with a sleep disorder asks her employer not to reassign her to a night shift because she has to maintain a regular schedule of sleeping at night. She currently doesn't have any limitations except when her sleep is disrupted. Then she has significant problems getting the sleep she needs. Even though the employee's sleep disorder isn't flaring up right now, we're going to look at her limitations as if they were active to determine whether she is substantially limited. That's Rule 7. And it doesn't matter that she's only substantially limited in sleeping because she only has to be substantially limited in one major life activity. That's Rule 8. So in this case, this person is likely covered by the ADA. Okay, we're finally up to Rule 9. This rule states that there is no specific time frame for how long an impairment or its effects have to last in order to be substantially limiting under the ADA. This means that temporary impairments can be disabilities. They don't have to be long-term or permanent to be covered. For example, if an individual has a back impairment that results in a 20-pound lifting restriction that lasts for several months, he is substantially limited in the major life activity of lifting and therefore meets the definition of disability. At the same time, this rule says that the duration of an impairment is a factor that is relevant in determining whether the impairment substantially limits a major life activity. Impairments that last only for a short period of time are typically not covered, although they may be covered if sufficiently severe. Bottom line here is that we don't automatically say that a temporary impairment isn't covered. We have to look at all the relevant factors. So we really don't know how long an impairment must last in order to be covered. And those are the major changes to the first prong of the definition of disability. Remember earlier I said there are 3 parts or prongs to the definition of disability. We've been talking about the first prong, also known as the actual disability prong. Before we talk about the other prongs of the definition, let's look at some examples of how these changes work under the first prong. Putting all this together, the regulations state that although the individualized assessment of whether someone has a disability can still be required, the individualized assessment of some kinds of impairments will virtually always result in a determination of disability. The following impairments are examples from the regulations of impairments that should be easily found to be substantially limiting a major life activity. Deafness substantially limits hearing, blindness seeing, an intellectual disability brain function, partially or completely missing limbs or mobility impairments requiring the use of a wheelchair, substantially limit musculoskeletal function. Autism, brain function. Cancer, normal cell growth. Cerebral palsy substantially limits brain function. Diabetes, endocrine function. Epilepsy, neurological function. HIV infection, immune function. Multiple sclerosis and muscular dystrophy, neurological function. And major depressive disorder, bipolar disorder, post-traumatic stress disorder, obsessive compulsive disorder, and schizophrenia substantially limit brain function. So if you're dealing with an individual who has one of these conditions, it might be best to simply get the diagnosis and assume the person is covered unless you have some strong reason to believe otherwise. For conditions that are not so obviously disabilities, the EEOC regulations state that in determining whether an individual is substantially limited in a major life activity, it may be useful in appropriate cases to consider, again as compared to most people in the general population, the condition under which the individual performs the major life activity, the manner in which the individual performs the major life activity, the duration of time it takes the individual to perform the major life activity, or how long the individual can perform the major life activity. Consideration of facts such as condition, manner, or duration may include, among other things, consideration of the difficulty, effort, or time required to perform a major life activity, pain experienced when performing a major life activity, the length of time a major life activity can be performed, and or the way an impairment affects the operation of a major bodily function. And remember, this is without considering the beneficial effects of any mitigating measures the person uses. Let's take a look at an example. A person with dyslexia, a learning disability that interferes with reading, recently obtained a degree in marketing and was offered a job with a marketing firm. After the job offer was made, the new hire disclosed she has dyslexia and asked that written communication be sent to her electronically and that screen reading software be provided for her computer. For those of you who are not familiar with this type of software, it can be installed on many electronic devices to read information out loud to the user. In trying to determine whether this person has a disability and is entitled to accommodation, some employers may want to consider the fact that she was able to obtain a high-level college degree and to conclude that she must not be that limited in learning. However, even though a person with a learning disability may achieve a high level of academic success, she may nevertheless be substantially limited in a major life activity of learning because of the additional time or effort she must spend to read, write, or learn compared to most people in the general population. This is the type of information the employer will need to determine whether the new hire meets the definition of disability. Okay, let's look at the other prongs of the definition of disability. Again, we've been talking about the first prong, the actual disability prong. The second prong is called the record of prong. An individual has a record of a disability if the individual has a history of or has been misclassified as having a mental or physical impairment that substantially limits one or more major life activities, but no longer has the impairment. The good news is that the terms substantially limits and major life activity under the record of prong of the definition of disability are the same terms used in the actual disability prong we just went over. So there's nothing new you have to learn here. We probably won't see too much use of this prong because so many people will now meet the first prong. But one thing you need to know is that if someone is covered under the record of prong, he may be entitled to a reasonable accommodation if needed and related to the past disability. Here's an example of how this might work. A person had a severe blood infection that was resistant to treatment. He had to undergo several rounds of extensive treatment that ultimately cured him, but left him with permanent but minor cognitive issues. He may be covered under the record of prong of the definition of disability. He no longer has an impairment, but when he did, he was substantially limited in immune functioning. If he has some cognitive problems from the treatment he went through, and maybe he needs some leave time for periodic medical follow-up, He's entitled to accommodations for both because the need stems from the disability that he had. Okay, now let's move on to the third prong of the definition of disability, the regarded as prong. This part of the definition is completely new and very broad. It covers anyone subjected to an action prohibited by the ADA because of an actual or perceived physical or mental impairment. It applies to actions such as hiring, demotion, promotion, termination, discipline, annual evaluations, compensation, and forcing someone out on leave. All of the decisions employers make about employees on a day-to-day basis. To be covered, an individual only has to establish that an employer discriminated against him because of a medical condition. He no longer has to show that the employer thought he was substantially limited in a major life activity. This is a very significant change because a person used to have to show that an employer thought he was substantially limited, which means basically trying to read the employer's mind. Of course, employers never said they thought someone was substantially limited. They really knew better than that. Now there are only two parts to a regarded as claim. One, the employer took an employment action, and two, the employer took the action because of an individual's actual or perceived impairment, period. One exception under the regarded as prong is that impairments that are transitory, lasting or expected to last 6 months or less, and minor are not covered. Remember earlier I said there was no time frame for the first or second prongs of the definition, but with regarded as, we do have a time frame. So if an employer can show that a person's impairment is both transitory and minor, the employer is probably off the hook. However, whether an impairment is transitory and minor is an objective standard. For example, an employer can't claim that it thought an employee had AIDS, but also thought AIDS was transitory and minor. No one objectively thinks that. Also, even if an employee can show that he was regarded as having a disability, the employer can win the case by showing it had a legal reason for taking the action it took. For example, an employer might show that the person really couldn't do the job, or maybe someone else who was more qualified was hired. One other thing I want to mention about the regarded as prong is that if a person is only covered under this prong, meaning the person does not have an actual disability or a record of a disability, then that person is not entitled to a reasonable accommodation under the ADA. The regarded as prong is about addressing discrimination based on myths or stereotypes employers have about people with disabilities. And with that, let's look at some examples of the regarded as prong. These are all examples of an employer regarding someone as having a disability. Remember, this doesn't necessarily mean the employer discriminated, but it establishes that the person has a disability and can get his ADA complaint investigated. Refusal to hire an applicant because of skin graft scars. Termination of an employee because of cancer. Termination of an employee with angina due to the belief he will pose a safety risk. Termination of an employee with bipolar disorder. And termination of an employee with a hand wound that the employer mistook as HIV infection. And that's it. Those are the major changes to the definition of disability. The main thing you should know now that you've heard all these changes is that the definition of disability is broad. A lot more people are going to be covered, and it shouldn't take that much effort to figure out if someone meets the definition of disability. So we're ready to move on to the workplace implications of these changes and some practical tips for dealing with them. Okay, let's start with reasonable accommodation. The Amendments Act did not change the definition of reasonable accommodation. However, as I mentioned, the Act does clarify that only individuals who meet the first, actual disability, or second, record of disability, parts of the definition are entitled to accommodations. Individuals who only meet the third part, regarded as, are not entitled to accommodations. Even though the definition of reasonable accommodation did not change, it's clear that with a broader definition of disability, more focus will be placed on providing reasonable accommodations. So I want to remind you of the flexibility built into the reasonable accommodation obligation under the ADA. For example, under the ADA, employers can choose among effective accommodation options, do not have to provide accommodations unless needed because of a disability, do not have to provide accommodations that pose an undue hardship, do not have to provide personal use items needed in accomplishing daily activities both on and off the job, do not have to make an accommodation for an individual who is not otherwise qualified for a position, and do not have to remove essential functions, create new jobs, or lower production standards. So keeping these guidelines in mind, let's look at some specific tips that you can take back to your workplace. First and foremost, it bears repeating that with the new, broader definition of disability, employers should no longer be spending a lot of time analyzing whether employees meet the definition of disability. Employers can still require medical documentation when an employee requests an accommodation and the disability and/or need for accommodation are not obvious, but the documentation related to determining whether someone has a disability should not be extensive. Instead, the focus should be on the accommodation, whether it is reasonable, whether it can be provided without an undue hardship, and whether there are other accommodations that can be considered. Second, do not confuse the definition of disability and accommodation. Remember that the definition of disability is an impairment that substantially limits at least one major life activity. Once an employer establishes that an employee is substantially limited in any major life activity, then the employer has established that the employee has a disability and is entitled to an accommodation for any limitations associated with the disability. The accommodation does not have to be for the limitation that established disability. It can be for any limitation associated with the disability, whether substantial or not. For example, remember the employee I mentioned earlier with breast cancer who established that she had a disability by showing that she is substantially limited in the major life activity of normal cell growth? Now let's say she needs an accommodation related to typing because of swelling in her arm caused by the treatment she's receiving for cancer. Even though she is not substantially limited in the use of her arm and hand, she is still entitled to an accommodation for typing because the limitation is related to her established disability. Next, make decisions that are job-related and consistent with business necessity. As mentioned previously, the Amendments Act broadens the definition of disability and places the focus on the actions taken by employers. One problem employers can have is making decisions based on assumptions about employees' medical conditions, which can lead to regarded as claims like we discussed earlier. To help avoid this problem, employers should focus on any performance or conduct problems that employees have and apply their policies in a uniform manner without making assumptions that a medical problem or disability is contributing to or causing the problem. In general, it is the employee's responsibility to let the employer know that a conduct or performance problem is disability related and to request an accommodation to overcome the problem. So there's usually no reason for an employer to bring up medical issues first. Also, when making decisions such as who to hire or promote, focus on qualifications for the job, not on perceptions about someone's disability or need for accommodation. And probably the most important thing employers can do is train frontline supervisors and managers. No amount of preparation will be effective unless employers train their frontline managers and supervisors, because the frontline usually has the most contact with employees on a day-to-day basis. If nothing else, employers should train their frontline to refrain from mentioning medical conditions unless relevant, to recognize accommodation requests, and to remember who to contact for assistance. Many employers, as part of their accommodation procedures, appoint a responsible person to handle accommodation requests, keep confidential medical information, and help avoid discriminatory employment decisions. Another important reason to train frontline supervisors and managers is to help reduce retaliation claims. The frontline needs to understand that making negative or derogatory remarks about someone's medical condition or in response to an accommodation request can be considered retaliation. And finally, employers should document their actions and reasons for the decisions they make. Because the focus of the ADA has shifted to whether employers discriminated on the basis of disability, documentation of actions and decisions can be very important if an employee alleges discrimination. In the past, many such allegations were never looked at because the employee couldn't meet the narrow definition of disability. Now, especially with the broad coverage under the regarded as part of the definition, most cases will hinge on whether an employer discriminated. So employers should keep accurate records because it can be difficult to remember what happened without good record keeping, and written records are generally considered more reliable than memory alone. Another important aspect of documentation is effective communication with employees. Many problems occur because employers do not let employees know, for example, how their performance needs to improve, the status of their accommodation requests, or why an accommodation request was denied. Employees need to be informed so they can have the opportunity to address performance problems or suggest alternative accommodation options. And that's it. I hope you have a better understanding of the changes the ADA Amendments Act and its regulations made, and how to apply the changes in your workplace. I've presented a lot of information today. If you need to review anything said, or if you want more information about the ADA Amendments Act, you can visit the EEOC's website at www.eeoc.gov and click on the ADA Amendments Act section, or visit JAN's ADA library located on the JAN site, which is askjan.org. And please don't hesitate to contact JAN. You can reach us toll-free at 800-526-7234 for voice, or 877-781-9403 for TTY, or visit us on the web at askjan.org. You can also find us on Twitter, Facebook, LinkedIn, and other social networks. We hope to talk to you soon, and again, thank you for making JAN a part of your training program.